please announce the case.
Okay, we are on the record in the Colt v. Plummer matter, case number D1756076-C.
Council appears to be the board members.
Good morning, Your Honor. Linda Lay, 12990, on behalf of defendant Alyssa Plummer, who is present.
Good morning, Your Honor. Bob Cercio, bar number 5247, the guardian ad litem for Preston Colt.
You don't have video, Mr. Cercio. You're calling in?
My video from my side shows active. I don't know why it's not going through. I apologize for the technical difficulty.
Okay. And we have Stacy. I see Stacy online.
Yes, and Marianne is here also.
Okay, so I'll ask Jeffrey Ann to swear the parties in. That's Alyssa, Stacy, and Marianne.
Please stand and raise your right hands. You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Okay, so you may be seated. I may mute the court. I will mute the courtroom to avoid the background noise. Now, this is I converted the trial to a status check due to COVID. I wanted to give everybody some of the recent developments that's been going on in the courthouse. There's been 5 deputy marshals that tested positive for COVID. We've had at least 14 cases of reported COVID, so it's very difficult to come in the courtroom. We can't do a trial via blue jeans because then everybody would have to wear masks, and it would be very difficult for the court to view the parties' facial demeanors with masks on. And so until it would be safe to come back into the courthouse, this trial would have to be set at a time when it can be done. We are also backed up about 5 months on trial settings, and there hasn't been any trials that really have not gone forward. Now, I understand that there are about a dozen cases I have that unfinished trials that need to finish before the end of the year's up, but some attorneys have chosen to, or for practical and logical reasons, they want the in-person trial, and this is the type of trial where we would need to do this in person. So it is what it is. I can keep you on the priority list, obviously, if there's a return to the courthouse, but right now the settings are in early 2021, and we have ongoing things going on with Preston, the child, and I understand he's still in therapy. So we're going to talk about it's a status check. We're going to talk about the guardian ad litem's report and then the therapy, how that is progressing. Now, I understand you also did, Ms. Lay, a subpoena for the trial, which isn't going to happen today for obvious reasons, for Miss Crystal Whipple, but I take it you did not, might have been helpful to get her input, but you did not forward the Blue Jeans link for her to appear by video today. So it's a shareable link, and you didn't, I don't know if you did or not, so it was too late to make an inquiry if she was going to appear today. So we're limited on information. Also, I believe everybody got to see a copy of the guardian ad litem's report, Mr. Cercio's report. It was sent to everybody with my, you guys didn't get the report? It was sent with my authority under a confidential gag order for everybody to read the report. Normally, in normal circumstances, I would just give it to the attorneys, but because of COVID, I transmitted it electronically so that both sides were able to read it. So Mom has an attorney, and Stacy and Marianne don't have attorneys. They should have been received. Has anyone not received the guardian ad litem report? And
We have received it, Your Honor.
you did receive it? Okay, so it is under a confidential gag order. It is not to be disseminated to any third parties, not published publicly for obvious reasons and public policy reasons to maintain the confidentiality. Okay, let me ask Ms. Slay, what's the situation with Crystal Whipple? She's continuing to be Preston's therapist.
Right, Your Honor. And Your Honor, I apologize. We did send the subpoena to her, and so when I got the note that it was a status check, I stated that, never mind, it's been continued. So she was under the impression that she didn't need to appear. I did shoot her an email right now just to see if maybe potentially she could hop on. From my discussions with her, she stated that there was Preston still withhold counseling, but Crystal is, she had another therapist also discuss with Preston starting last month, I believe. But he is still, the family therapist, but he is still withhold counseling, and Crystal Whipple is still overseeing his sessions.
Now, I understand in the guardian ad litem's report, which is several pages, I've read it, that Mr. Cercio made a decision not to talk to Crystal Whipple, so I'd like him to speak to that. I understand maybe one of the parties or both parties had approached you about talking to Crystal Whipple, Mr. Cercio?
Yes, Your Honor, this is Bob speaking. I was asked several times to speak to Ms. Whipple, and I made the decision not to after meeting Preston for the first time.
Who asked you? Did both ask you?
It was actually Ms. Lay. I may have had that discussion with Ms. Cantor, but frankly, I do not recall specifically. She's shaking her head no, so I'll just say that was a request from Ms. Lay. Let me back up for a second and speak briefly to the communications that I've had. I've approached this as being the voice for the child, and to be as independent as possible from both sides. And I have provided only procedural information, maybe how the court works, and what my role would be. And also I relayed Preston's requests, which are stated in the report. There was a moment when it was possible that my role might have been expanded into a mediator, but the parties are just too far apart for that to have progressed any further. In regard to Ms. Whipple, my 3 meetings with the child, there's nothing overtly about him that would give me pause or to even identify a problem with him. He seems like a genuinely age-appropriate, relaxed young man. And I did, other than there were a few things that there's a level of distrustfulness that he has with the process, but given the file that I read, that would seem perfectly natural to me. The other thing is that I did not want to have my words as an attorney be given undue weight by a counselor. There are times when someone of my age and experience in the community, that somehow my words might be given more weight than they should be in the treatment process. So I was concerned about that as well. But the long and the short of it is, there was nothing that gave me an immediate cause to identify a problem, and I thought that the child spoke to me candidly.
Okay, I want to just at least give the summary that I was able to glean off of your 20-plus page report. The summary is that I believe Preston wants to resume contact with Stacy, the paternal aunt.
Yes, in the first meeting with him, I asked him directly. He became very excited and said, "Ooh, is she there?" thinking that she was in my office. And then for the next 2 meetings, his requests to contact with her were unsolicited. He brought those up himself.
And what were your impressions when you discussed his relationship with the paternal grandmother?
It was primarily, and I mean no insult, maybe because Stacy was the first one brought up, that there might be some sense of that was on the top of his mind. There nothing negative was said about grandmother, but he seems to be bonded very strongly with Miss Cantor and wanted to speak with her. He did not necessarily want to visit or stay with her during the first two conversations, but by the third conversation, he had expanded, wanting to go over there. He did not feel the need to be protected or to have someone else with him, and he expanded that request to include the grandmother, the maternal grandmother.
Okay.
I'm sorry, paternal grandmother.
Yeah. Okay. Let me ask Stacy. What is your level of contact with Preston?
We have not seen nor talked to him in the last 6 months since before our last court date on Valentine's Day, February 14th. We have had no contact whatsoever with him.
Understood. Okay, so what we're gonna, I have to rule on today is whether we're going to reinitiate the contact, because it appears from the guardian ad litem report the child does want contact with you, Stacy, and I'm not sure about the grandmother, but I think Mr. Cercio is saying that the boy wanted to, he clearly made it known that he wants to reinitiate contact with you. Okay, as far as
I'm sorry, Judge Moss, we cut out for a little bit, so we missed the last 30 seconds.
yes, the boy wants to reinitiate contact with the paternal aunt, Stacy Cantor, and I have to make a ruling today on whether or not we'll reinitiate contact. Well, Mr. Cercio obviously hasn't been on the case. He was appointed after the last date of trial, which was on, I believe, February 20th. And yes, I felt that it was in Preston's best interest that he have a voice, obviously. Now, you did ask, I don't know if both sides did, but it appears clearly Miss Lay's office or the mom maybe talked to Mr. Cercio and wanted him to talk to Crystal Whipple. Stacy, you didn't make that request?
No, Your Honor, because based off Crystal's testimony and on the February 14th, February 14th court hearing, she confirmed that Preston was with Alyssa when he acquired the burn mark, and I don't know what the conversation was after that, but she also confirmed that he was in her care during that time frame as well. So Preston, he's only repeating what Alyssa and her family is telling him to say to her. So I don't have any confidence. And Crystal herself has told me that she fears for Preston's safety with Alyssa.
Okay, that's what you know. Has Mary Ann had any interaction with Crystal Whipple?
No. Well, she has called her after the court hearing because you had said that we would be able to have a visit through her, and she has not returned a single phone call.
I called her once a week for 10 weeks.
Once a week for 10 weeks, and no.
She never called me back. I left a message each time, once a week.
Right.
See me. And he expressed interest in seeing me as well, Your Honor.
Okay. Yeah. Just so to put this in perspective, Mr. Cercio was not there at the February 20th, which led to his appointment as the guardian ad litem. With respect to that, and I know Grandma had filed a motion, but I think there was problems with service, so the motion was not adjudicated. But in terms of, at that time, Mr. Cercio, Stacy, I believe Stacy herself was represented by attorney Carol Barnes, who subsequently withdrew from representation. And there was a bench conference with Carol Barnes and Linda Lay, and I believe Carrie Herdick, her co-counsel, and Grandma was asked, and she waived the being present during the bench conference off the record, and Miss Barnes spoke with, and their interests were not opposed, so Miss Barnes spoke to the grandma, I guess, and then the grandma went back on the record, and Grandma said she said that's fine to waive that, and allowed Miss Barnes and Miss Lay and Miss Hurdick to speak with the court and Crystal Whipple about Preston's current therapy and what the result was from the trial. And then we went back on the record. I pronounced that Preston should have at least 6 months of continued therapy. I stopped the contact with the paternal side of the family to allow the child to stabilize, because according to Miss Whipple, he was in a unstable state and very fragile, and so this is the point now where we're checking on whether or not contact should resume with the paternal family. So you may not have known the context, Mr. Cercio, but I understand. I respect your decision not to speak with Crystal Whipple, and you may not have known the context because the bench conference was obviously off the record, and only what we went back on the video, the pronouncement was allow the child to stabilize for the next 6 months.
Yes, ma'am. Before I spoke with the child, I spoke for about 30 minutes each to each side, Ms. Cantor, and then, well, actually not Ms. Cantor, mostly through Ms. Barnes. As she exited the case, she handed me a file with, well, those are exhibits 1 through 4 attached. It was a lot of information that I read, including the CPS reports, and I'm aware of, I believe that I'm sufficiently aware of the hearing for the safety concerns regarding the child. So it's not that I met the child out of a blind. It was with the context of reading as much of the file as I could. But again, my impressions, and I have to qualify this, my impressions are only via the Zoom meetings. I did not have the ability to meet with the child in person. Under better health circumstances, I would have had him in the office. We have a small play area. I would have just let him get comfortable, sit on the couch, play with toys, and then ease into the conversations with him. We had to do this by Zoom, though certainly something is lost in that process. So that might flavor my thoughts on this. But again, nothing overt stood out at me as a problem. It didn't seem to line up with the history of the case. The child I met, I thought age-appropriate reactions, somewhat relaxed, given the circumstances. His attention span, I thought, was appropriate. The few seconds of interactions that I saw him with his mother as she would exit the conference room where I spoke with him alone, they seemed like genuine mother and son, touching selves. I'll be in the other room, don't worry, that type of, those moments that sometimes tell us a lot about relationships. So my thoughts on my interview were not without some level of understanding of the case.
Okay, so the question has to be answered today of whether or not the court feels it would be helpful to the trier of fact if you speak to Preston's therapist. Ms. Whipple has been involved with Preston, well, at least for probably well over a year or maybe longer. And she 2 years? Okay. So she has a lot of information about Preston that may assist you with getting a more informative report. But are you opposed to that if the court directs the guardian ad litem to get more information and speak with Preston's therapist? Hang on, Stacy. I saw your hand raised. So,
I am not opposed to doing that. I would make clear in my initial contact that I would be speaking on behalf of the child to the court, and that any conversations that we have to not view me as a controlling voice on the case, but merely as the representative of the child.
absolutely, absolutely. Okay, Ms. Cantor, do you have any question or comment?
The issue I have with that is it's strictly hearsay. Alyssa obviously has him, he has been completely alienated from in-person visits, going to school, any type of outside contact with his family or anybody in the world, basically. And the whole premise of this case is that she's burning him and coaching him to say that it's this side of the family. And I think Bob saw that during the last interview when he wanted Dorena Slater to sit there and watch him while he, and let me just bring this up, now there's new allegations that I'm the one telling him to hurt himself. For the last 2 years, it's been Marianne. So now there's new allegations that I'm the one telling him to hurt himself. And he wanted Dorena to sit there while he told the truth about how Auntie told him to do this.
I totally understand the respective extremely polarized positions between you and Alyssa, but this is what I have. I mean, Ms. Whipple is Preston's therapist, so she has to obviously act in Preston's best interest. She hasn't been, she's still in the middle of her testimony, obviously, for the purposes of this trial, but she's doing the ongoing therapy. I am inclined, and I will likely make orders today to reinitiate the contact with the paternal side of the family. It appears that based on the guardian ad litem's verbal report and written report to the court, that the child is relaxed, appears to be stable after 6 months of additional therapy. And so the assumption is, I mean, I'm a little bit of a disadvantage, and I'm just like Mr. Cercio says, I mean, his word doesn't control the case, and neither does Ms. Whipple's testimony or information provided to the court. We have to piece everything together in that context. But it appears, the disadvantage I mentioned is that I just don't have information from Ms. Whipple today. It was a resumption of trial converted into a status check, not just on the setting of the next trial date, but also a report back from Ms. Whipple on the 6-month mark. And Ms. Whipple did not submit, I mean, I don't babysit my cases, but Ms. Whipple did not submit an updated progress report. Ms. Whipple, I'm not sure if she reached out to you, Mr. Cercio. I assume she did not. One moment. And I knew that, and everybody knew that this was the 6-month mark, and I had no report voluntarily submitted by Ms. Whipple, knowing that she was subpoenaed for trial, and maybe it was because it was last minute, in fairness to Mom's side, that she was taken off and not recorded to the trial. Maybe there was a misunderstanding that this was a 6-month status check, and no report from Ms. Whipple, and I understand Mr. Cercio. I wrote Mr. Cercio's decision for part of his initial report to the court not to speak with Ms. Whipple at this point and just report back what he knows. And he knows, and I know he did a thorough job reading the history of the case. There's a lot of information. This case is a very long history. And he knows the contacts. He apparently had communications with the prior attorney, Carol Barnes. He accepted documents from Carol Barnes right before she withdrew from the case. Okay, let me go with Ms. Lay first, and then I will go with Ms. Cantor. So, one moment, Stacy.
Thank you, Your Honor. As you are aware that, yes, Preston is in a good state right now. And going back to your comment earlier that, you know, you were thinking about doing the visits or whatnot because he seems stable, that is with the caveat that he is in with the custody of his mom only. But going back to maybe there was a misunderstanding, Your Honor, in regards to the order, because I know that in February, Carol Barnes' associate did write, you know, the order that was in place, and Ms. Whipple did reach out about a month ago asking for an order to show that she needed to provide a report, and it went through all the orders, and there was, I know we discussed it in court, but on paper there was no order stating that she was to provide a report. So I gave her the court's email just to say, you know, maybe you can send it directly to the clerk. I don't know, but these are the orders I do have. I know that she did reach out and she wanted to make sure that she was complying. So that might have been a misunderstanding because I don't think that was.
We had zero communications from you, procedurally even. If you had contacted my office, we had zero contact. The case sat for 6 months. You were doing whatever you were doing, talking to Miss Whipple. We had no idea of that. I'll accept your representation that Miss Whipple diligently asked a month ago, and she relied on your representations, counsel. Nobody would have twisted her arm or stopped her from submitting a updated report, knowing logically that this was a 6-month status check, and I don't have a report. I'm not pointing fingers at you, Ms. Lay, but it just seems common sense. We're coming
Right,
back.
no, I understand.
And
Right, I understand.
one moment. We have zero idea what communications you were having. So this is the first time I'm hearing that Ms. Whipple diligently reached out to you, mom's lawyer, with neither the court nor the other side knowing about such communication, which is proper. It's procedural, so it's not, you know, ex parte in any nature. But if it's a status check, nobody reached out to the court for an update or what's going on. And we would have gladly responded to what maybe you might, what Ms. Whipple would have been asking. Had we known about that communication 1 month ago, I would have said absolutely. We are going to. Attorneys call. They ask what's going on with the COVID and the trials. We would have given you our best answers at that time. And a month ago, we would have tried to. A month ago, we would have tried to proceed with the trial in the courtroom. However, with the new developments, and you know, I'm not privy to say any personal, you know, information about those. You know, we can't. I mean, we don't know who the 14 cases of COVID are. One had a family member who died. Okay, died at the hospital because of COVID, and it's, you know, a month ago we didn't know about it, but that's why I set the status check and converted it from a trial last week because of any new developments and what's going to happen with the trial situation. And this case is impacted obviously because my term ends at the end of the year. And before I forget, I will tell you, you may stay on as a Department I case. There are 2 females running in my department, but there are 4 brand new domestic judges and there is a very good chance you will be randomly assigned to one of the 4 brand new domestic judges. And these are going to be first-time new people who are going to, for the first time, take the bench. They are attorneys. So you will not be randomly reassigned to one of the veteran judges. it would either be State Department I, or you'll be sent to another brand new judge, not one of the veteran judges, who will have to potentially finish the trial. Fortunately, I have very, very detailed type notes on every piece of testimony that was taken since day one. So they would have the videos available, they would have the notes, and the trial, if this thing is set in 2021. You remain on my priority list, obviously, if we can come back into the courtroom, but there's other impacts of other unfinished trials that I have to finish, and it's based on the age of the case. And you are on probably at the top in terms of oldest case pending. We started this trial like fall of last year, going on a year, I suppose, or earlier in the year. I think, I don't know what day. February was about day 3. So we might have started earlier in the year. I have trials older than you that have been going on day 17, day 15, etc. Okay, so as far as any other additional comments, I will hear them from both sides. I took the time to explain the context of everything here, and whether the court will initiate the contact based on the information. I have to say, and I appreciate your candor to the court, Ms. Lay, that you did have that conversation with Ms. Whipple. You had every option to say, yeah, please go ahead, and you did. You proactively, you did your diligence and said, here's the department's email. Go ahead and write a report. Write a report to the judge, and the judge will distribute it to both sides. And it would be under a gag order, just like giving you the garden ad litem report. But unfortunately, we're at this point today. The other side is obviously pressing to have the contact initiated, and so it's the judge's call whether or not it would be safe, obviously, and stable for the child to press for that. So if you have any additional comments, given the not having all the information today, but I do have a good, very, very, very thorough report from our pro bono guardian ad litem, Mr. Tercio. Anything you wanted to add? Is your client obviously is probably polarized and saying, don't start up the contact, wait for Ms. Whipple to write her report, and err on the side of caution. I guess that's your argument. So,
well, that's so funny, Judge Moss. I know that what Alyssa, I know the sides are polarized. I did reach out to Ms. Cantor in order to find a middle ground, but yes, we are polarized. The only reason why I asked about Mr. Cercio is contacting Ms. Whipple is for obvious reasons, but if we may, Your Honor, because of what's going on, can we at least do a gradual visitation in terms of like video conferencing first to see how it is, and then moving forward with supervised visits to see what happens, because it would be a 180 for Preston, and also there are concerns about, what's going on after the fact, after our hearing, but my only thing is, I think a good compromise, at least at this point, without seeing Dr. Holland's report and Dr. Whipple's notes and reports, at least for the time being until we reconvene again, if we can at least do the Zoom or whatever it is, video conference, so that Preston can get readjusted. I'm not saying one way or the other, I just think maybe steps. And I understand that my client is opposed to it, but at the same time, I think for purposes of moving this case forward, that would be our argument, that I agree that maybe there will be some contact, but until we get definitive information from Dr. Holland and Whipple.
That's what attorneys do. They leave it to, they leave it to the judge to make these decisions. So I understand, and we have a lot of options here. So you're asking, for purposes of the court minutes, you are asking graduated supervised visitation. Okay, I get that. Stacy was obviously going to oppose that and give me her request. I do want to enter a finding in the court minutes today that it does not appear to the court that the mother has alienated Preston from the paternal side of the family, in particular Stacy. Stacy is of the mindset that there's alienation going on, but I don't see that, Stacy, per the guardian ad litem, Mr. Cercio's report, that Preston is not alienated because he jumps up and down and he says, is my auntie there? Is she there? Can I see her? When can I see her? And Mr. Cercio obviously clearly reported that in his report. Preston does want to see you. Preston is not alienated from you. He asks about you, and it's a matter of what type of visitation you will have. So, Stacy, I will let you speak on your behalf now.
Thank you, Your Honor. Yes, I agree that's Preston's desires. However, I want to call note about the coaching where he wanted to make sure that his maternal side of the family saw that he was telling them that, what was it?
Matches.
That I taught him how to use matches, and that I telling him to hurt himself. And so that right there, I feel is a red flag to indicate that what we have been saying is true. Also, I want to bring up that both counselors, there was Katie, the in-home counselor, who after the trial, I sent text messages between her and I. I don't know if you were able to read those. I did drop a copy off with Bob. She confirms that Preston was with Alyssa that weekend that he acquired the burn mark, and she also confirms that, yes, that was a burn mark, and no, he could not be hurting himself on the couch, as Alyssa has stated. Crystal has also confirmed.
You gave him matches.
How did I give him matches? Hold on. So if I gave him matches when I exchanged him to you, wouldn't you see that he had matches and took that from him? That's completely...
I don't pick my son's pockets.
I'm going to mute them. I don't want arguing in my courtroom. They'll get their chance.
I don't even have matches. This kind of speaks to her mental capacity. Like, the fact that, and not to mention that for the last 2 years, it was my mother. So I want to point out that whoever's going against her for custody is who she tells Preston to say all these things about. Yeah. First it was John, then it was Marianne, now it's me, because I'm the one going against her for custody.
Okay, let me ask Mr. Cercio, because when I read that portion in your report, Mr. Cercio, did you find that, was it spontaneous? Does the boy have a little bit of an imagination? Does he have confusion about who he is referring?
I'd like to make my observations very clear on this. On the first 2 visits, when Preston was presented by his mother, I found the child to be candid, and I had no sense of coaching about him. It was on the 3rd visit, when he was brought by his paternal grandmother, that there was a noticeable difference.
Sorry, that was not the... Sorry, Bob.
Please let me finish, Stacy. That it was at his request for his paternal grandmother to be present, and then he was a bit agitated towards the end. In the middle, I thought he was very much like the first 2 visits that I had with him. So I don't think that it's. I don't think from my observations anyone should or could draw a conclusion that there has been coaching by mother. That is not what I was trying to relay. It was only on the last visit when paternal grandmother was present. And his ability to retain this, I need to make sure I say this in front of my grandmother so I say it right, that type of sense. It was only for that 1 visit limited. My observations are limited to only that 1 visit. The other 2 with mother, I got no sense of that from the other 2 visits.
Okay, so Bob, you're saying paternal grandmother. That would mean Marianne Colt, and that's incorrect because neither one of us have seen Preston in the last 6 months.
I'm sorry, I misspoke. Miss Slater.
Thank you.
That
is Alyssa's mother.
Yes.
I see. Yes, that's noted in your report, Mr. Cercio.
Thank you.
That's clearly noted in your report. Okay. Stacy, anything else that you want to say, or you have what kind of contact are you requesting to the court?
I would like my visits reinstated. I mean, there has been no danger or allegations of danger with me. The fact that Crystal was here and confirmed, both Crystal and Katie, who, by the way, is no longer Alyssa's in-home counselor. Alyssa went off on her and made a grown woman cry. Katie told me this herself, and Crystal told me this.
Who is Katie?
This is hearsay.
Katie is the in-home counselor that was going to Alyssa's house to check on Preston. And Alyssa would call her and take her.
With Crystal?
Katie works with Crystal, or she used to. Now she's no longer with Hope Counseling, is what Dr. Holland had told me.
Okay.
Because Alyssa...
Yeah. Let me get a response from Ms. Lay on this alleged incident with Katie. Ms. Lay.
Hi, Your Honor. With Katie? Can you hear us?
Yes. Katie works with Crystal. Katie goes to Mom's house, and apparently what Stacy knows is that Mom made Katie cry, and Katie doesn't want to go there, or Katie doesn't work there anymore. Okay.
Your Honor, may Ms. Plummer speak to this issue, because she would probably accurately state it better than I can.
Sure.
Okay, Katie, before the last trial, Katie informed me that Preston told her that he was hurting himself on something. He was pushing himself up and down on it, and I thought it was a part of the couch. I could not figure out what he was using. He would not tell me. Then right before trial, apparently she contacted Miss Cantor, and she broke HIPAA law. She sent her pictures. She sent her all kinds of stuff, which is why she got fired, by the way. Now, I did not know what Preston was hurting himself on. It wasn't until Preston found out that he no longer was going to see them anymore that he finally broke down and gave me the matches and told me that Stacy gave him the matches and showed him. He went like this, Mom. I said, Preston, how do you even know how to use them? And he goes, Mom, she showed me how to do it like this. And he said he blew it out and he put it on his back. And that's how he had been doing it. I had no idea. I don't smoke. I removed all of the matches out of my house that were for candles. I no longer have them in my house. And if you look at my son's back now, he hasn't even a mark on him. You can't even tell that it ever happened. There's no scars. There's no nothing. And my son is doing better because he's not being coached by them to hurt himself or to lie anymore. And I please am begging you, please don't put him back in harm's way. He's doing so good. He is doing so good.
Okay, thank you. All right.
What Katie sent me was evidence, and Alyssa, being the vindictive person she is, went and got her fired. She spoke to this. This is the same counselor that she said she gave a key to her home against her better judgment because she wanted her to have access and everything like that. Well, Katie told me that Alyssa was hallucinating things and called her and would take up Preston's time, and I don't know the exact incident of why Alyssa went off on her, but she went off and showed her true self, the same what we've been watching, what you've seen in the court, in the earlier years. There was a reason that my brother had full custody, and just because he died doesn't automatically make her a good parent. And
did you list Katie? Did Carol Barnes list Katie as a witness?
No, because
for testifying.
Came the first time.
Oh,
She oversaw Crystal.
Hold on, Mom. I don't know. These were her witnesses. I only recently found out this information after the last court date. I had Carol withdraw me because I've spent hundreds and thousands of dollars on this court case, and I can, I can represent myself. I know the case better than anyone. But if I will, I'll try. My mom knows how to do the motions. I'll see if she can subpoena her. But I also want to make a note that the burn mark is the same thing that goes back 3 years. So how can that mark be identical if all of a sudden I'm the one giving him matches, which I don't even use matches in my home. I don't smoke. I don't know where she's even coming up with this. But how could that match create the same mark that a Puma Stone has, a Nail on the Couch has, Marianne Birmingham has, Sean has Birmingham. Now, how can people...
Okay.
When does it end? When does her lies?
Right. When does her lies end? This we have seen.
One last question to Ms. Okay. Today is not the trial, obviously. All right. The trial will have to resume. One last question to Mr. Cercio. Give me a little more context on the matches reference, please, Mr. Cercio.
It was only in the third meeting that I had with him, and my notes were translated directly into the report. So this is my current recollection. So I don't think my words today will be all that much different than what's in my report. He said, I need to tell you that my aunt showed me how to burn myself. This is all paraphrasing, not quotes. And I said, with what? And he said, with matches. And I asked him, well, do you know how to light a match? And at that time, he held up both hands in front of him and made a striking gesture as one would do with a set of matches.
And that was in the presence of the maternal grandmother?
No, what happened was she was present. He looked at her. He looked back at the camera and said, my auntie has told me to say that I was hurting myself, and looked back at his maternal grandmother. Again, these are not recorded, so I don't know whether she stayed in the room for the matching part or whether he had left by that part, but it was within a very close proximity of the start of the meeting, maybe the first 5 minutes. And then that did not come up again, although towards the end, when he had reached his tolerance level, for want of a better phrase, or his attention span, after he had spoken for a little bit, and I said, is there anything else you want to mention? That's when he started to get agitated again and walked around the office to find his grandmother with the iPad. And then I spoke with Miss Lay and Miss Hertig for a few minutes following that, just to explain that he left agitated, but he was not agitated during the span that most of the span that I was speaking with him. Does that help?
It does. I know that it's a tough question, but I wanted to know, when he made that statement, the spontaneity of the statement, it wasn't specifically elicited.
It felt coached.
Oh, thank you. Okay. You had a total of 3 visits, and
But when I say that, as I mentioned before, none of this was present when Mother made the drop-off. It was only with Miss Slater's 3rd visit. And I don't know that 3 visits is enough to really formulate and much more of an opinion. Would I find out more, or would Miss Whipple know more with more contacts? I think so, but that was just was a moment that just stood out.
Reading between the lines here, I mean, what my impression is that it's possible. I mean, the impression is that it's possible Alyssa is not coaching Preston, but the grandmother, knowing that her daughter was in litigation, might have done the coaching knowing that she was going to drop it off.
Within the one-way communications, that's what I would infer also.
Yeah.
And Your Honor, if I may, and going back to what Mr. Sergio said, that third visit was very different from the first two, maybe because Grandma was there to drop him off. But I just wanted to clarify that the iPad is in our conference room, and so Preston came in, and Grandma and me, and then, he wanted Bob, he was like, I want Bob to meet my grandma. And I said, okay, that's fine. So when Bob got onto the Zoom call, he said, this is my grandma, and he started going off a tangent about, I need to tell the truth, and he kept even giving me the iPad saying, I want to tell the truth, I want to tell the truth, and it was, and I'm just going to be candid, it was very different, right, the third time. And so I said, okay, well, we're going to leave right now, and he was like, well, I want my grandma to stay.
I can't have counsel testify, obviously.
I understand. Sorry, I just wanted to clarify that.
She was there.
One moment.
I'm sorry.
You don't want to inject yourself, counsel, because then you will not be the counsel if you're going to testify on this experience at your law office at trial. Okay. I've set this case for an hour. I'm on limited time. Stacy, you have be real brief because then I'm going to make some orders.
I just want to also bring note to the January 29th observation with me and at Donna's house when he ran out to his mom and said, I told the truth now, can you buy me Pokemon? That was in your notes that you read in the court. I also want to make reference to that. This is an ongoing thing. Alyssa and both her mother are coaching him to say that it's this side of the family, when the time frames don't even add up whatsoever, which is why she changed the story to him hurting himself now. But that's impossible.
Okay. At this point, I have several things, and please, everybody not interrupt because it's all in my mind here and on my notes, and I want to make sure my court clerk takes very good notes for the court minutes. So one of those findings was, per the guardian ad litem's report, the child during the GAL interviews appeared to be relaxed, and for majority of those visits, until the mention of the matches incident, the child suddenly got agitated. So I presume that needs to be explored more. I will permit if they want the Katie. What's her last name? Katie. What is it? Can somebody?
Yeah, THIBEAUX.
Okay, can you somebody type that in the chat box, the Katie's name, so my court clerk has that spelled correctly if you know the name. Okay, she will be permitted if you want to subpoena her for the next day at trial. She'll be permitted to testify. I don't know if maternal grandmother's on your witness list, Ms. Lay, so she may want to speak and testify under oath to that. So Ms. Slater is the maternal grandmother is an anticipated witness for the continuation of the trial. As far as resuming the visits, first of all, you're saying now that Crystal Whipple is transitioning as a counselor, or Crystal is still going to be Preston's main counselor?
Can I talk on?
I'll let Alyssa, but before Alyssa speaks, so Hannah is the counselor that has been meeting with Preston, but Crystal, Hannah Hartman.
Type her name in the chat box also. So she'll be, now that's new information, so she will, you are going to probably subpoena her to testify for the trial. Mr. Cercio will stay on board for purposes of the Mr. Cercio continuation of the trial, but he will have ongoing updates for the court, whether it's me or the new judge, as far as visits and checking in on Preston, so that we make sure we get up-to-date information. obviously.
Your Honor, can we have them do in-person visits rather than a 30-minute Zoom call? Because this case is so complicated that you're not going to be able to assess without him actually being around Preston and really getting to know him and away from the Alyssa's control.
Okay.
Mr. Cercio?
Yeah.
Right, so the point here is suggesting that she will bring Preston to wherever is a neutral place and have in person as long as there's another.
No, she was saying that you want me to bring him to Cercio for 30 minutes in person?
Oh, for Cercio, in his report said that he likes to do a 1 to 2 hour evaluation.
The only reason why we haven't been doing that is because of COVID-19.
Right. So
May I speak to this, please?
Yeah.
We have several people in our office, myself included, that reside with at-risk individuals. So it's, I have no problem staying on for the Zoom meetings, and if we see some change in the restrictions for contact, I'm comfortable with that. But the child's been meeting for a very long time with counselors. I believe that I have a rapport with the child with the Zoom. I can continue on basically checking in every 30 days, and I think that's probably enough to maintain contact. What I don't want this to turn into is, Bob, did you meet the child? Did you look under a shirt for burn marks? Or was there some where I become a witness more than the representative of the child? Any of those type of observations should be made by counselors or by pediatricians, not by the attorneys.
Right.
So I think that the report that has been going on, I think is adequate. I can bring it to 3 weeks or every 2 weeks for a little bit. I don't mind meeting the child. He's a pleasant young man. And to provide periodic updates to the court. But I am reluctant to bring in any clients
Right.
across the board because of the risk factors currently present.
Right. And keep in mind, he is doing this as a pro bono court-appointed guardian ad litem, so he's not charging anything for his services, and we don't have a lot of money in going on both sides, and we don't have, money to do any kind of updated custody evaluations. Those run very expensive. So
Dr. Holland has been retained on this by Ms. Cantor.
yes, that's another point I want to bring up. Because of Alyssa's new allegations and completely fabricated lies, this is costing more than what was supposed to be, and I'd like to request her to pay half, to be responsible for half.
I can't force that, and she is I don't recall if she's court appointed or your attorney, Carol Barnes, chose her as your expert.
Yeah, Carol Barnes wanted to petition for her. You said okay without prejudice. However, because of Alyssa's new allegations, which she's sending them on wild goose chases, saying that Sean had an open case with Ethan, who's his older son, which is completely a lie. So now I have to give her that mother's contact information, and then it's just escalating because of her lies. So I'd like her to be responsible for paying for some of this. It's only fair.
I think she was your hired expert. Ms. Lay, do you recall if she was court appointed or
She's court appointed.
Court appointed?
Sorry, Your Honor.
I agreed to pay the initial deposit assessment, but like I said, this is running way more than what was anticipated because of Alyssa's saying more lies.
Okay. Ms. Lay, what's your understanding?
Your Honor, what had happened was, during the discovery phase of this case, the counsel did not retain an expert, which is fine, it's their case. And so, in the middle of trial, because we had Crystal Whipple to testify, she didn't testify at this point yet, because we had her as a witness, at some point during trial, counsel wanted us to stipulate to have Dr. Holland in the middle of trial, evaluate this case. We were reluctant on our end because, as you know, we are doing this pro bono as well, and Ms. Hummer does not have the funds to pay half of the expert. So in this case, we could have simply said, you know what, no, because discovery closed, due diligence was not done, or for whatever reason.
Okay, it's financial. It's financial, and I can't force the financial. And if somebody wanted the expert, I would, yes, court appoint them, but somebody would have to pay if they wanted a court-appointed expert. And if you disagree, Stacey, then we'd have to drop Holland unless you want to continue paying her without prejudice, because the only reason how it works is at the conclusion of the trial, if depending on, what the outcome of the trial is, you may seek reimbursement for having to front the money and pay Holland to prove your case, I presume. But she's sort of neutral in that respect, in that she's court appointed, but you're submitting all the payments to her. But if you can't, I can't force it on you either to continue to pay her due to financial hardship on your side as well. So I leave that option with you, and you're fronting the money, but based on the outcome, you may seek the reimbursement depending on the outcome of the trial. So that's kind of how it would work. All right. The findings, I'm over time, so I don't want to have to mute you guys.
Oh, Crystal Whipple had messaged that she was available, but I understand. I'll tell her. I'll let her know.
Well, we're going to do this. I'll keep an eye, okay? I'll keep an eye and monitor how the visits are going, number one. Number two, certainly Crystal Whipple, she's still the active counselor for Preston. I will direct the Garden ad litem to, have a phone conference or Zoom meeting with Crystal to get additional context and information about what's going on with Preston, so Preston can have a proper voice to the court. Number three, Ms. Whipple can be available at the next status check on how visits are going, because I'm going to order the visits. Number four, Ms. Whipple can now write her report, since we didn't get it in time for today's hearing, but it's not going to delay or hold up the initiating of visits. Number five, the JEA will do an amended order setting trial for the future trial dates. And again, right now, due to the extremely heavy calendar load and being backed up 5 months since March, April, May, June, July, August, we're five months backed up due to COVID and finishing up other trials. It's difficult. So right now we're doing the early dates in early 2021. Mind you, you could stay Department I, you could be randomly reassigned to the 4 brand new judges. Like in all my other unfinished trials, 3 of them opted for the in-person. I actually, gave them a choice, but this is the type of case we have to do this case in person because the judge needs to see everybody in the courtroom, and we can't testify with masks on. So with the masks on, I cannot see the facial demeanors. We can't do it by blue jeans because there's lots of exhibits, and there's just, it can't be done with this, the complexity of this trial. So it's going to have to be set for in person at a point where we don't have the masks on. But the new judge, they might have a different policy than me. And with the masks on, you don't want to say somebody's going to complain that the judge wasn't able to see their facial demeanors, etc. And there is because of the COVID death, 14 cases, there might be some unreported cases. It's possible there are court employees that don't know that they're COVID positive, and they still continue to come to work, come into the building, exposing themselves to everyone. And also with the 5 deputy marshals, it's really difficult at this point right now. We will continue to monitor that, you know, on an ongoing basis. So you're still on my radar in terms of if I can get back into the courthouse. Again, neither one of us here that's present at this hearing is privy or mandated to disclose whether or not, you know, they have underlying conditions that place you at risk, whether or not you have a family member that also could, you know, want to place at risk, et cetera. And Mr. Cercio also with his law office. I'm not going to require Mr. Cercio. It's his option at any time if there's an in-person visit available. It's just not going to happen right now at his law office. You know, we don't have any, and I don't want to bring anybody, you know, we could offer up space in our courthouse, but that's kind of worse because it's a very, very public building. But you'll have to work those logistics out with Mr. Cercio. But at a minimum, he is to continue with every 30 days is a good recommendation to do a checkup on Preston. So Preston can add more information about, you know, what his voice to the court is. And for context, yes, Mr. Cercio will get with Crystal Whipple regarding that. The child appears to be stable based on his voice. He's relaxed. I would have to admonish both sides. Again, do not discuss the litigation. Do not disparage the other party, the other side of the family. And do not, don't bring up matches. Don't bring up a couch part, metal part. You're supposed to just pretty much enjoy your time with the child and keep him, stress-free. Stress-free. He had 6 months. I do have one question to both sides, and we'll keep it brief. Give me short answers. Obviously, I can't go on forever. I'm going to ask it to Alyssa. Did Mom, Alyssa, send any pictures or videos or any updates to the paternal side of the family, considering they had no contact in 6 months? So you got completely nothing, other than just maybe what you find out from Cercio.
Right. And it was
not true. So I wrote to her several times.
My mom wrote to her several times on the Talking Parents to wish Kristen a happy birthday and see how he's doing.
And ask her if she needed anything.
Oh, and to ask her if she needed anything during the COVID
began, because I was working and she wasn't. And
right. I can't, you know, it's 6 months. You guys are very polarized. I can't hold it against Alyssa because the order was, yes, we would suspend the in-person contact. I just asked because logically to me, you know, if she wanted to send a picture or a video, you know, one way, that is not going to harm Preston because 6 months, he's probably an inch taller. Maybe he gained weight, lost weight, or here's an activity he's doing. I would have I would have obviously seen no harm sending it one way just to keep them apprised. I mean, one of the best interests of the child factors is promoting a relationship, but these parties are so polarized. You know, a court will potentially might weigh in on that. The door was not closed on that, but everybody is very, very attuned to strict orders as far as that with no contact. This child is fragile. So I'm saying I'm not going to hold it against Alyssa. I just thought I would ask if she had done that. But she said she was following court orders. So, I don't know if I would have signed that and wait if we were in the trial today. So, we'll initiate we will do the visits in terms of what the purpose of what the suspending of the contact was, obviously, was to get the child stabilized. It appears that it's been helping. We don't have the report from Crystal Whipple. I don't know if we'll hear anything differently, but we'll monitor this. So Mr. Cercio is going to, starting from today, we'll have the 30-day mark. So we will have the 30-day mark. You'll have one Zoom meeting with Preston He may opt for an extra Zoom meeting or do that Zoom meeting from Stacy's house during her visitation time, so we get a different context there, and how Preston talks to his attorney from the paternal family's house. As a matter of this visit is granted for Stacy. There was a change in the middle of the trial or in the middle of the litigation, because Stacy was going to pursue, obviously, the custody or at a minimum visitation rights, and Marianne, obviously, she somewhat kind of took a back seat to that, and so Carol Barnes was representing Stacy. But Stacy's kind of the main party on the paternal side, so I'm going to reinitiate the visits with Stacy. It's for Stacy, kind of Stacy only, but if Grandma wants to have contact Stacy, it's your visits. Right now, I don't know. Obviously, there's so many things going on both sides. Grandma obviously can have the contact with Preston, but I will ask you, Stacy, and I'm sure you won't have any objection. That if Grandma would have contact with Preston, that it would be Stacy and Grandma together, basically. Because Stacy, I'm giving you your visits. So if Grandma's going to come around or tag along, that it'd be Stacy and Grandma. It could be Stacy and Preston have them for the visits. The child does not appear, based on his voice, he wants to see his Aunt Stacy. He wondered if she was there with and so I will rule that Stacy's visits would resume. We will monitor that for 30 days. We'll come back to court with a Whipple report, an updated supplemental GAL report. Could be 1 or 2 pages, or nothing extensive like the first initial report, on how the visits are going and anything else that Preston wants to tell the court. Those visits, I believe, were weekend visits. Is that correct, Stacy?
Yes. Your Honor, for reinstating that, and I just want to confirm, not that I have any concern whatsoever about my mother being around him unsupervised. For the purpose of this litigation, I have completely did a process of elimination and taken her out of the picture because of the allegations Alyssa had Preston saying, which only left me. And when Preston was around my mom, it was basically the entire family or me or myself. So I will continue to do that, so you can see that it's not any of us, but it's Alyssa, and she's coaching him to say that. I do want to request, however, that my sister Damar, and this was the way that it was before, that she's allowed to do the pickups and drop-offs, just in case I'm tied up on a meeting for work or anything. It's good to have a backup and not it be solely on me.
Well, wait a minute. Marianne would be a driver?
No, not Marianne. My sister Damara. She was the one that testified on the court.
Yeah. Did I authorize that before?
Yes. She was the other person that was able to do the pickoffs, just because she literally lives right down the street from Alyssa.
If I authorize and order that, then that order can be reactivated. Jamara can help with transport.
Yes.
I'm okay with that.
Are you working from home, or you're a school administrator or a teacher?
Okay.
Yes, Stacy.
No, I'm actually a federal contractor for the U.S. government, and I do work from home.
Oh, okay. I thought I'm for some reason I thought you had worked for a school. Okay.
No, I do.
All right, good. So you're quarantining at home and sheltering in place. So Preston will obviously, you'll follow the quarantine shelter place, and we do like everybody else does. So your visits will take place. Preston will stay home unless you go to a park or something. But we do the social distancing. I just have to ask a couple of protocols. May sound silly, but I have to make sure you have appropriate sanitary supplies in your house.
I even bought him a little mask.
Okay, yeah, you have little masks for him, reusable, washable masks. You still have his set of clothes, extra clothing, outfits there, everything he needs, correct?
Yes, he has 2 bedrooms here. His clothes are probably too small, so I will have to buy him new clothes, but that's not an issue.
And so it would be permissible, like if you need to go to Walmart, Target, or whatever to go shopping to get any clothes or
Right.
new outfits. That's fine. So we'll follow that protocols in both households. And was it every weekend or one weekend?
See them every week.
What was the old order?
The initial no, the initial order was every weekend, and then Alyssa started having to say things about me, and then it switched to every other weekend. But that time, that distance in between, and then no one. By the time I get him, the marks are old, so there really isn't anything that anyone can do.
Alyssa's attorney wanted gradual, so I'm going to go with the every other weekend. Feel free to, take some videos of your interactions discreetly, obviously, like what you do, photos, family photos, and feel free to file them. Just, one or two, just to see. If you do have a video, send them on Dropbox and send the link. And send it, obviously, anything you file or send to us, you have to send it to Miss Lay. And if that's where I could see how the videos are going. Alyssa, you can also do the same thing. What's been going on recently? What activities have you done in the summertime with Preston? I could see what's going on in your household. So we'll get a Crystal Whipple report. Hannah is also a involved counselor, so I don't know if they're going to write a joint report from Hope Counseling, or Crystal's taking the lead. Yeah, you guys work it out, one or both, and we'll get a updated report from Mr. Cercio. Okay.
Should I be put on a service list or rely upon? Okay.
Yes, the GAL obviously will be copied on everything and be on the e-serve list of anything filed. So today starts day one. You have a 30-day mark to schedule a visit. And like I said, for context, maybe a Zoom check with at Stacy's house. So, but it is on the weekend, Mr. Cercio. I don't know.
It's not a problem. I work all the time.
Oh, I appreciate that. I really appreciate your pro bono efforts here. And we'll set this out 45 days. Everybody has 45 days to get their, well, I don't know, 30-day mark. It might be, I'd say 6 to 8 weeks out. That will take us to September, third week or last week of September, Jeffrey Ann in the courtroom. Can you help me find a date?
Would you like
Your Honor, thank you for
probably an hour slot. And I know it, and I'll try to keep it to an hour. We went way over time, and I've got I think a 10 o'clock case is waiting for me, an emergency case. So we need to wrap it up with a court date, and we'll start. We'll start this week, and then she'll have the every other. The times are.
I know, but I'm now doing homeschooling. So it's not going to be picked up at the school. It's not going to. It's completely different. So
Can we do the pick up and drop off at either Bob's or Holland's? Actually, I would like to do the drop off at Holland's office on Monday at.
No, I can't do that. That's on the other side of the world, and I don't have gas money.
You have a car now, and I've been doing. I've been going to that side.
Okay, I muted both of you. Either if you guys are it'd have to be at the family court gate. I don't know what the halfway point is to your houses. If we were going to do the school, you could still kind of do at the school if that was agreed upon before. It's not my job to make it convenient for both of you and the gas money and all that, but we have to do the transport. You want your visits to happen? I mean,
Your Honor, I have a suggestion. How about there are McDonald's all over the place? They can pick a midpoint McDonald's, and the parties can go in and grab a soda with a time stamp receipt to show when they arrived.
I would suggest to Stacy also, look, I'm reinitiating your visits. If it means a few dollars, few cents of gas to go pick up from Melissa, you are going to get to see Preston. So you want to just, at least for the next 45 days, receiving parent to pick up.
Your Honor, the gap isn't the issue. I want it to be at a third-party intervention. I want Holland to do an observation on him when I drop him off. So I'm going to schedule visits with her so he can see her when he's directly coming from my house, so that can mitigate.
I don't know if Holland will do it on a Friday. You're supposed to start at 3 o'clock, aren't you? When school starts.
Well, when I'm dropping him off, I'll drop him off on the Monday.
You can do it on a Friday or a Monday. Does Alyssa live near Holland's office?
Yeah, Holland's on that side of town. I mean, it's not down the street. Like, it wasn't exactly convenient like it was for her at the school. But, I mean, this is for the litigation purposes and to eliminate the accusations from her. I want Holland to do an observation when he's coming directly from my home. So she can't have him say anything.
If Holland can do it, is there going to be an issue with Alyssa dropping off at Dr. Holland's office? Ms. Lay?
She's going to make an issue.
They dropped off. Oh, they're trying to, looks like they dropped off. Now some guest is appearing. They lost internet connection.
Yes, Your Honor. I just want to have a third party involved. That way, this back and forth and the accusations we can put an end to this.
I don't know if they're listening in. I can't. I don't want to have one-sided conversations while we're recording. And okay. I just looked at my computer, and it looks like they had dropped off. But there's a guest there.
I'm sorry, Your Honor. Well.
Now there's a 5205 number. That must be Miss Lay's cell phone.
I'm sorry. Hi, hello. We just dialed in. I'm sorry, the iPad died.
When did you drop off? What part did you miss?
We dropped off with the McDonald's, and you stated after Mr. Sergio discussed, and you were going into the McDonald's.
Okay. Listen. I'm out of time. If the parties continue and not figure it out, you guys can continue talking if you want to do a reasonable location. All I can say is it would be either a family court. It would be a family.
Yeah, we can keep it at family court. We're fine with family court. We just need to set a time, and we're good.
So Alyssa got to spend gas, and Stacey got to spend gas, and come to the family court. There are video cameras there. It's 24/7. It'll be Friday at, he's going to do virtual school. Friday at 3 o'clock still seems appropriate.
Can we do it at 5 o'clock? Because we have class in the morning.
You have class in the morning? What does that have to do with it?
We have homeschooling now. When does it end? It's at 4:30, so I mean...
It ends at 4:30, Your Honor, so would 5 o'clock be okay?
No, Your Honor, I would like a third-party intervention in this, just to put an end to all these allegations, and now she's saying that I'm the one telling him this.
I don't have an issue with that.
I don't have to do with what time we're picking up and dropping off.
And the school, what time does school end?
We stop at 4:30.
Okay, so they stop at 4:30, Your Honor. She is homeschooling the child. She's not doing it through Clark County. Just so you are aware, she decided that she was going to homeschool Preston.
Well, as far as the homeschooling... As far as
we were muted.
Yeah, I muted you because I wanted to.
I'm sorry.
I'm going an hour and a half. I'm 30 minutes late. I've kept Mr. Cercio on from his very busy schedule, and I need to finish the ruling on this case, and I can't have the parties arguing on this. And I don't. It's not productive to listen for you guys go on at each other for another hour just to figure out where to pick up Preston, obviously. So the default is
for a fair assessment to have a third-party intervention so the court can better understand.
I heard what you said, so please let me finish my ruling. I heard what you said. Logistics is a problem, okay? If Dr. Holland will assist you with the logistics, I will ask Ms. Lay to tell her client to comply because if it's important to Holland's report, I will ask the mom to comply unless she has a really good reason. And I don't want to hear excuses like my car broke down. Okay? So please don't interrupt. Okay, I'm tired of this. The default order is at the family courthouse because it's the safest place and there are video cameras there. Both sides will obviously, per the prior orders, I believe there's prior orders, they're allowed to record audio and video just for each of their protection on the he said, she said. It'll be Friday at 3 o'clock until, what time does it normally end? Per the court order, we're going to follow the order. Is it 6 o'clock?
Monday at 3.
Oh, Monday at 3? Yes. Okay, so it'll have to be... Stop! I'm going to mute you. It'll end at Sunday. I'll end it at 6 o'clock because of the schooling, the virtual schooling. Okay? I don't know what the distance learning is with the Clark County School District. Sometimes they're just doing the Zoom meeting classes in the morning and then they're done. And then it might be half days. You get me more information on that, but I just don't see it will impact. This order impacts on Preston's schooling. Status check, Ms. Clark, did you type in a date?
No, I didn't.
Look.
I was waiting for you to instruct me on that. But
Okay,
you want a 1 hour slot.
You didn't find anything, Jeffrey Ann?
I can do a 1 hour slot.
This is set for an hour.
But
Okay,
it's gonna
third
take-
week in September. We
Okay, I
have
can set it from, do you want it on a Monday or a Tuesday?
Thursday the 17th. I can put you on. Thursday the 17th at from 9 to 10.
I'm good with that, Your Honor.
I appreciate that, Mr.
You
Cercio.
said
9:17. I'm going to type it in the chat box at 10. 9:17, 9 to 10 a.m. This will go in the court minutes. It's a 1 hour slot, and Blue Jeans link sent to the GAL to Whipple. I believe they're going to join us. Okay. All right. I don't know where Holland is in terms of what she's doing and gathering information, but she's still in the middle of doing her evaluation in the middle of this trial. But because I only have an hour setting, we can just see her input. I don't know if she'll have a report, but that's really more of a trial issue from the evaluators, from the court standpoint. So that's more of a trial issue. Put it also in the chat box here. JEA shall file an amended order setting trial. Stacy starts her visits this weekend. Okay, Friday at 3 to Sunday at 6 p.m. It's still daylight out in the summertime, so you have to be at the family court gate. Okay, hopefully that's enough time for you to write your report. One of these 2 weekend visits is going to happen, Mr. Cercio.
No problem.
Thank you. All right, we'll get reports. I'll see if I can. I'll have a JEA put a reminder maybe like a week before we meet up to see if those reports are in there. We try our best. And Mr. Cercio, just transmit your report straight to the court, and then we would disseminate it under a confidential gag order, obviously to both sides electronically. Same. All right, thank you. Jeffrey Ann, go off the record, and I'll see you at the next court hearing. Thank you.
Your Honor.
And who's to prepare, Judge? Who's going to prepare?
Thank you, Your Honor.